Let's stay with that story. In News Just In, we understand that Advocate Mkhwebane's lawyers have given the president until Monday to indicate whether or not he will appear before the parliamentary inquiry into her fitness to hold office. Now, in a lawyer that we've seen as the SABC, the lawyers argue that the president has some matters to clarify to the committee, and should the president not be willing to voluntarily avail himself, they say they're exploring further options. And we saw this building up over time. Even last week when, UDM leader, for example, Bantu Olomisa said that he must come, and then the lawyers also indicating, and then we saw the statement by the presidency saying that the president did not make allegations against the public protector. He simply suspended her when it comes to, in line with the Constitution, Section 194, making such provisions for him to do so, for this inquiry to continue. But let's explore this further, and what does it mean then for these proceedings, and how can we see this unfold going forward? We speak now to legal expert and commentator Advocate Modidima Mannya, who joins us live now. I know, Advocate, we've pulled you out of your birthday celebrations. Thank you so much for joining us. Let's start with this. It was a long time coming, and we saw it being touched on, a number of times last week. Are you surprised that we got to a point where we're now seeing an official letter saying the president must voluntarily appear before this particular committee?
Yes, I'm actually surprised that the threat has been carried out, and especially in the manner that it has been done. I'm not sure that the president has got any role to play here. I've just browsed through the letter, and I don't necessarily think that there's anything that has to do with the president in terms of the evidence required at the hearing.
Now, let's then look at the fact that, as you say, because he released a statement last week to say he's not going to do this because this was his prerogative as per the Constitution. He didn't make allegations. They're calling on him to voluntarily appear before the commission, or as they say, they'll take necessary steps come Monday if they do not get their way. How do you see this one play out? Could he voluntarily do so, or are we seeing a looming battle in court here?
Look, let's separate the issues. I think the one issue that I think is completely irrelevant to the inquiry is the decision to suspend. It doesn't even belong to Parliament. It's a matter of the president, and as far as we know, it is a matter that is being dealt with in the court of law. But I think separately, and as you see from the letter, there seems to be a suggestion that because the president had a matter of the CR7 bank accounts in court and he deposed to affidavits, he somewhat has some relevance in terms of whether the public protector was incompetent or acted in a proper manner. That alone remains a challenge and a problem. But I must indicate from a procedural point of view, Bongi, and people may not be aware, that if you bring a witness under subpoena to an inquiry of this nature, that witness has no obligation to consult with you. So I'm not even sure how they are going to lead the president, even if he were to agree or to go there under subpoena. The second issue is that the decision to subpoena witnesses is the decision of the chairperson in terms of the directions that have been issued. Now, they still have to go and justify to the chairperson of the Section 194 inquiry why it is necessary to bring the president to give evidence, what would be the relevance of his evidence, and what matters fall within his personal knowledge. It's not just because he didn't make a complaint that he is not required. Anybody who may assist with providing evidence will be required, but I'm not sure whether the evidence of the president in this matter would be relevant at all.
How do you see it then, play out in terms of the inquiry? Could it further delay the proceedings if this goes to court?
Well, I suppose the chairperson would make a determination. If he makes a determination that he's not going to issue a subpoena against the president, we will have to see whether the public protector's lawyers will want to take any legal step. But I don't think any such step would delay the proceedings because the president would not be the only witness. Maybe it may delay at some point in the sense that all the other witnesses may be exhausted and the only evidence that may be required would be this one. This is if there would even be a basis in law to approach a court, because that may as well not be.
All right, let's see then how this one plays out. Thank you so much for your time this evening. I know we stole you from your birthday celebrations. Go then and enjoy them. That is Advocate Modidima Mannya, who was looking at this letter that we've now seen that is has given the president until Monday to respond whether or not he is going to voluntarily appear before the Section 194 inquiry into the fitness of the suspended public protector, Advocate Mkhwebane, to hold office, or whether or not this is a matter that we're now going to see the committee dealing with it, because the president even released a statement last week. So it'll be interesting to see how this one plays out.